Thanks to Palante for hosting this. It's important, J-51, it sounds like some kind of technical and arcane legal thing that, may not concern many people, but in fact, J-51 has had a tremendous impact on tenants' rights and building improvements throughout the city for many, many decades. And I can tell you that tens of thousands of tenants who thought that they might not be protected by rent stabilization eventually found out that they were protected by rent stabilization by virtue of the fact that the owner of their building received a J-51 benefit. I'm going to go into the details about that a little bit later. As a lawyer, what we often do is a kind of a diagnostic when people come into our offices with landlord-tenant problems. One of the first questions we ask is, are you rent stabilized? Because it has a dramatic impact on whether or not they're being charged the proper rent, whether or not their lease renewal rights are being honored, whether or not services are being provided, and consequently we need to know the answer to that. And among the questions that we explore, in addition to the age of the building and the size of the building, typically pre-1974, it should have 6 or more units in it, and it should not be subject to a new certificate of occupancy. But also, we would be inquiring into whether or not the owner took advantage of the J-51 tax abatement program. The program is basically a program designed to give special tax abatements to owners who embark upon improvements in their building. And I'll let you HPD discuss the details of that. And there are sort of two epics of J-51. The last one, which came to a conclusion in 2022, and the new one, which is going to be the focus of HPD's presentation tonight, which is the new J-51, or sometimes referred to as J-51R. But the reason why I'm giving this little prelude is I want to emphasize that J-51 can have a dramatic impact on whether or not you as a tenant would be protected. It also has a dramatic impact on improving the housing stock in the city. And I think we're going to hear that the new program is actually better targeted at improving the lower income housing stock. It doesn't solve all problems. There are still some big problems out there to address, which I'm going to talk about at the end. But it's been, I think, an outstanding program with positive effects. And I know the folks at HPD work very hard to implement these things. I don't know where the city would be without HPD in terms of code enforcement, in terms of tax incentives, in terms of management of certain other regulated housing. So I'm glad they agreed to participate, and I'll turn it over to John Leonard, who is the Executive Director of Tax Incentive Programs at HPD.
Yeah, hi everyone. So myself and LaFleur will be taking this part of the presentation. Do we have the slides to go up? Great. So we could skip ahead to the second slide. So just to give a broad overview in terms of what the purpose of J-51 is and how it works, the overall purpose of the program is to incentivize investment in the physical health and efficiency of buildings across the city without increasing rents to low rent units. And as you hear more about the J-51 reform program, I would keep that purpose in mind. We'll explain how it manages to serve that purpose and to a much better extent than the old J-51 program that's being replaced. The basic summary of how the benefit works is it's a tax abatement of up to 70% of the approved certified reasonable cost for qualifying work. And that can be on a property's tax bills for between 12 and 20 years, depending on when it runs out. And the certified reasonable cost is what is granted in relation to eligible alterations or improvements to an existing building. So this is not new construction. These are all existing buildings with rent stabilized units already in them. You could jump to the next slide, I guess. Yeah, go ahead, LaFleur.
So the objectives of the J-51 reform program is to target the aging housing stock within the city, within the 5 boroughs. And it is to encourage improvement in critical maintenance and improvement in buildings that are needed. Um, One of the main features of the new program, as John mentioned, is um, low maintaining and preserving low rents in the rental buildings. And in order to do so, we've now introduced an AMI requirement that never existed in the previous program. And we'll get into more details as to that AMI requirement. We also updated the allowable work to reflect the cost that is more equitable with the market rates of cost of work, unlike with the old program that had an outdated cost schedule. We are making the eligibility criteria for the program to qualify for the program a little bit more simple. The prior program had several tiered types of applications that can be filed and was very cumbersome and a little complicated. And now we've made it, a lot more simplified. And again, this is to encourage repairs and upgrades to meet the city's sustainability goals and to promote the general maintenance and habitability of your buildings. So pre-existing buildings. So no new constructions, as some of you may be familiar with other programs, tax incentive programs that are offered through HPD that encourage newer construction. This program is specifically targeted to um, our aging housing stock.
Yeah, the program has been around in various iterations since the 1950s. The most recent version of the program that's being replaced didn't have any thresholds for low rents specifically to be targeted by the program. And like LaFleur mentioned, the certified reasonable costs were quite outdated. We were getting many complaints that the certified reasonable costs were not lining up with what owners were actually spending on their repairs. And so one of the major uh, improvements with the J-51 reform program is to update those costs. There's 4 main types of projects that are eligible. So for those of you that are in the audience that are tenants, you may be thinking about which of these 4 categories your particular building might be able to fall under. There are rental projects, which have to meet a new rent threshold requirement, where at least 50% of the units have to have existing rent stabilized rents, legal rents at or below 80% of the area median income. And once if they meet that threshold, they can be a qualifying rental project. There's also homeownership projects, which needs to have an average assessed value of the entire building, no more than 45,000 per dwelling unit as of the commencement date. And so that really limits buildings that have high assessed values, luxury home ownership buildings, for example, projects in high value neighborhoods would also be excluded by this. So this is really targeting much more the buildings that need these types of repairs. And then lastly, there's buildings that are owned and operated by Mitchell Lama, which you might be familiar with. If you haven't heard that term, you could find some info online or even on HPD's website about Mitchell Lamas, or a redevelopment company. My understanding would be like an old Article 5 type of redevelopment company that owns the building. And then lastly, there's any project that receives substantial governmental assistance. So that would be something that's received, for example, HPD financing to do rehabilitation work, and has a regulatory agreement generally restricting the incomes and the rents of units. Those buildings receiving that substantial governmental assistance don't need to meet the same rent threshold or the same assessed value requirements as the homeownership buildings.
So, for the purpose of this presentation, just focusing on rental buildings and home ownership buildings. And if you are in a rental building, how do you know if you'll qualify? So, 50% of the units within that building has to be at or below 80% area median income. And what does that mean? So the rent threshold that we are using for the current applications that are being accepted is based on the 2024 rents. And these rents that you see before you are rents where the tenant does not pay any utility. So when we say 30% of 80% AMI, this is referring to the rents after you subtract the utilities or the legal rent. That is what will then qualify as 30% of 80% AMI or 80% AMI if the tenant does not pay utilities. So as you can see here, one bedroom, the threshold is 2330 up to a three bedroom at 3230. Okay, and so in order for a landlord or a building to qualify for any repairs, any rehab work that was done, one of the main qualifying factors that never existed prior to the new reform program is now an AMI threshold. And similarly for home ownership, so in a co-op or a condo, the qualifying factor is the assessed valuation. What is the assessed valuation? It's in the simplest of forms, it's the total taxable value of your property divided by the number of residential units. I know it's kind of small, but if you can see on the slide, the taxable value in the example that we give is about 2.4 million divided by the 96 units. And that gives you an average assessed value of 25,000. And so this property will qualify for the new program because it is well below the threshold of 45,000.
Yeah, and I just want to make note on that other slide. So those rents that are there are the maximum rents at an 80% AMI threshold for a unit to be qualifying. That assumes that tenants don't pay any utilities. If the tenants are paying utilities, there's a utility allowance that reduces the maximum allowable rent. And I also want to make note, if anyone in the audience is a tenant in a building that might be receiving J-51 reform, if your particular rent is above this threshold, it doesn't mean the building won't be able to qualify. The building just has to meet 50% of those units at or below those rents. Yeah, we could go to the next slide. So what are eligible costs? There is a schedule of a few hundred different items that are qualifying work. Typical items include insulation work, air sealing, air sealing around vents, air conditioners, etc. Heating and cooling systems are very important. Windows, parapets, hollow metal doors, meaning apartment entry doors, are an item that can qualify. Lighting controls, etc. Basics building systems. So we're not talking about amenities like a swimming pool or a gym being put into the building. We're talking about health and safety related quality of life repairs that are needed for the existing housing stock that the program is targeting. For buildings to qualify, they have to meet a minimum scope of $1,500 per dwelling unit. And that has to be for the entire building. They can't say, well, we did work on 5 units and that's more than 1,500 per those 5 dwelling units. It has to be that 1,500 per dwelling unit of the entire building that's subject to the application. These dates you see here on the third bullet point of June 30th, 2022 and June 30th, 2026, that's when construction must have been completed by. And that earliest date in 2022 picks up exactly where the old J-51 program left off in terms of work that can qualify. So the new program picks up from the old. There's no project that should be able to choose between the old program and the new program. I do want to note, though, that since we're talking about benefits covering specific items of work, it is possible for a project receiving old J-51 benefits to still qualify for the new program and get both benefits simultaneously. Once work is started within that window between June 2022 and June of 2026, the work has to be completed within 30 months. And And then the next bullet point covers if you're in an existing building that's expanding cubic content, let's say a 4-story building is adding a fifth story or adding a penthouse unit on the top, any work that's being done on that expansion of the building is not eligible for benefits. And the table below is just a partial list of CRC items. You can find more on our website. The schedule is available in a PDF format, and you can see not only the items that qualify, but the allowance, the maximum certified reasonable cost for those items, as well as the units of measurement, which vary between programs.
So how will the new J-51 work? As previously mentioned, this is geared towards lowering your property tax bill. All right, and so if you do qualify, the eligibility for rentals, 50% of units at 80% AMI, and of course different eligibility for SGA and Mitchell-Lama requirements. Right, co-op and condos have to meet the assessed valuation of $45,000, and eligible construction must be completed after June 29, 2022, prior to June 30th, 2026. Now that it may seem like a strange timeline, however, the old program, if work completed after June 29, 2022, those rules will not apply to that work. So it's very important if you do wish to apply for benefits for the new J-51 program to be aware of when your work completed, not just when it started, but when it completed. And moving forward also for work that should complete prior to June 30th, 2026. We have here a sample that will demonstrate how benefits will be calculated. As John mentioned previously, there is a set cost schedule available on our website that lists per item the type of work that can be claimed. In our example here, we have asbestos removal, which is very important. We often see this in installation of boiler burners or replacement of boiler burners and just abatement. And in this example, we see the pricing for asbestos removal and roof replacement. And the total certified reasonable cost is calculated at $447,000 for this example. The way that the benefits will be applied, however, is at 70% of that certified reasonable cost. So, oops. So 70% of this certified reasonable cost will allot you $335,000 in abatement, and this is applied over a period of up to 20 years. However, this 335,000 can run out because it is allotted at 8.33% annually. So if the certified reasonable cost amount is higher, obviously it can last a little bit longer. So whatever the amount is, it's based on the amount of work that is performed and the total calculated certified reasonable cost. In this example, this amount will be spread out over up to 20 years at $27,000 per year. And in this example, you can see that in year one, the tax bill is for $400,500. The actual abatement applied being $27,000, and so your annual tax amount is reduced after your annual taxes abatement is deducted to $307,000. So as mentioned before, the abatement can run out before the 20 years. So essentially, the benefit is for us is dependent on the amount, and the amount that is allocated at 8.33% annually.
Okay, this next slide might be difficult to make out, but it's an example of what a property tax bill looks like for a property receiving J-51 benefits. These property tax bills are publicly available through Department of Finance's website, and you can, if you have the borough block and lot of the building that you live in, you can look for these tax bills, and see whether or not there's current J-51, or once it receives J-51, you can see the impact that the J-51 benefits are having on the property's tax bills. And so it might be a little bit difficult to see. The things highlighted there are the pertinent information showing you what the assessed value is, for example, and what the taxes would have been without the J-51 benefits. If there are other benefits on the property, and it is possible to receive some other types of benefits simultaneously to J-51, so long as those other benefits aren't for rehabilitation work, for example. So if you're in a unit, let's say, that is receiving SCREE benefits, DREE or DREE benefits, STAR, for example, if they're unit-specific types of programs that don't get approval based on the rehabilitation of the building or of the unit itself, it should be able to coexist with J-51. And so you'll see any concurrent benefits on there in addition to a J-51 abatement. In fact, I think in that example, there is a solar abatement already on the property. And so you can see the two coexisting.
So how does J-51 support tenants? Our aim is to maintain affordability in our aging housing stock. So we're here to help to ensure necessary work is done on the physical health of pre-existing buildings. Property owners must provide notice to tenants prior to commencement of work. So in order to qualify, one of the qualifying documents that must be submitted with an application are what we refer to as pre-filings. And one of those pre-filings are notice to tenants and notice of intent and an affidavit to attest to having properly notified the tenants. Construction work completed for J-51 are the cost cannot be passed on to the tenants, as one of the affidavits that will be filed in conjunction with the application is a waiver of MCI increases. And so therefore, if a landlord decides to perform rehabilitation work on a building, they cannot pass that cost on to the tenants. Along with the AMI requirements, they are not allowed to increase the rent simply because of the rehab, as they will be signing a waiver for MCI increases. Qualifying rents must maintain rent stabilization throughout the duration of time that they're receiving J-51R benefits. And that is also something that's carried over from the old program, where during the period that they received J-51 benefits, they had to remain rent stabilized. And going forward with the new program, that is the same requirement. And the new J-51 program, along with the old program, we will not issue a certificate of eligibility or issue benefits to landlords if there are any open violations on this property. So DOB violations or HPD violations must be cleared before we can approve an application for benefits for J-51.
Okay, so there's some instructions there that may be useful if there's any building owners that are in the audience. We have a web page for both the old J-51 and the new program. The new program is called J-51 Reform. If you do a quick Google search of J-51 Reform HPD, it'll be the first result that comes up. There's plenty of contact information both on the website and there on the slide. There's a pre-construction portion of the application. Both of these, by the way, are available as zip files. So you just have to extract them after you download them, and all the necessary files are there. There's a pre-construction portion of the application, which includes a notice of intent to apply to HPD, which is very important. There's also a notice to tenants. And so tenants who are rental tenants or homeownership unit occupants do need to be notified that work is happening and that the building owner intends to apply for J-51. And so we expect owners or their filing reps to download this pre-construction package to file the necessary paperwork if they have any intention of applying. There's also an affidavit to HPD affirming that the notice to tenants was done properly. The post-construction portion of the application is everything that gets submitted after work is completed if the owner still wishes to apply for benefits. There is a basic application form along with an Excel workbook. The workbook includes a claim detail of the work that's being claimed for benefits. It includes a rent roll in order to illustrate that the building meets the rent threshold requirements for rental buildings, of course, which we also check against HDR records to ensure that the building does qualify. There's also a variety of affidavits there. There's an architect's and engineer's affidavit, an affidavit of ownership, and Energy Star compliance, for example, meaning new appliances. There is a requirement for those appliances to be Energy Star compliant, even if those are not necessarily qualifying for J-51. And then proof of eligible construction costs, owners have to illustrate to us the costs that they made, expended in terms of doing the work. And so it's an entire application package that gets submitted to us within 4 months of the post-completion portion has to be submitted within 4 months of the completion of work. And I think that's the last slide that we have.
Okay. Thank you, John, and thank you, LaFleur. I think Tim wanted to follow up, right?
Yes, yes. Thank you, John and LaFleur, for that excellent presentation. And I'm going to switch gears a little bit because now I'm going to be focusing more on the tenant side. And I think you've had a sort of an excellent overview of what this new program permits. Unfortunately, we have to kind of dive back into history over the last really 30 or more years to get a clear focus on, what type of problems tenants may be confronted with in conjunction with the J-51 status of their apartment. It does get a little complicated because there are, the two different programs, the original J-51 and the new J-51 reform, which is post 2022. In the critical consequence of the new J-51 for tenants is that it does protect you against MCI increases. It does guarantee your rent stabilized status if the building wasn't otherwise rent stabilized for the duration of the program. It will also cover in some instances, well, in all instances where a smaller building, 3, 4, or 5 unit building is receiving J-51, they also become rent stabilized, which would not otherwise be the case. So that's the new program, and that's the protections that are afforded there. Now, it's very often the case that a tenant will come into either Palante or my office and say, my landlord wants to throw me out, or my landlord wants to increase my rent by, thousands of dollars a month. And I don't know whether I'm rent stabilized or not. Can you tell me, what my status is? And, we look at the size of the building, we look at the age of the building, and we also ask for a rent registration history, which you can get through DHCR. And if you just Google, how to get my rent registration history, DHCR, you'll come up with a bunch of hits and they'll tell you how to get it. It's pretty straightforward. I think you can get it from folks at Palante as well. But once you get your rent registration history, you can look and see whether or not the apartment is registered as rent stabilized. And in some cases, many cases, you may find that registration ceased as of a certain time between the mid-1990s and 2019. And the registration ceased in many cases legitimately because of high rent deregulation. In most cases, the high rent deregulation was vacancy deregulation. The apartment reached a threshold initially of $2,000 or more upon vacancy. And so the next tenant would come out of rent stabilization. That threshold moved up over time to like over $2,700. But if the apartment reached that deregulation threshold, you came out of stabilization. And with respect to high income deregulation, the numbers went from $250,000 down to 175 if you were if it was occupied by a tenant who was in that income bracket. Then they could face deregulation. But primarily, the vast majority of cases occurred with vacancy deregulation. So how does J51 impact on that? Well, J51 preserved rent stabilization, notwithstanding the high rent vacancy deregulation thresholds. Now, it didn't do that forever, and this is where it gets complicated. In 1993, the legislature first adopted a high rent deregulation statute. In 1996, DHCR took the position that if the receipt of the J51 benefits was the sole reason for the building being subject to rent regulation, then it would be deregulated. On its face, the DHCR relied on the text of the statute, but the Court of Appeals in 2009 said that DHCR read the statute wrong, and that in fact, if it was subject to J51 at any point, whether or not that was the sole reason for the unit being stabilized, it would be stabilized. And this had a dramatic impact on, there was a class action suit involving Stuyvesant Town, Peter Cooper Village, several thousand units which had been deregulated. The court found again in 2009 were actually re-regulated. And with the settlement of that suit, there was a consent decree which kept those tenants protected through June of 2020. And with the adoption of the Housing Stability and Tenant Protection Act of 2019, all of those units actually came back into stabilization on their own, because on June 14th, 2019, the high rent deregulation was repealed. And so because of that, the new J51 and more recent coverage of buildings under J51 has not had as much of a dramatic impact, because several 100,000 units came out of rent stabilization because of high rent deregulation during that period from the mid-1990s through 2019. And tens of thousands of those units remained under stabilization or were put back under stabilization by virtue of the fact that they received J51 abatements. So when you get a rent registration history that says, for example, that a unit was high rent deregulated, say in 2005 or 2015, at a time when the high rent deregulation was in effect, you want to try your best to find out whether or not that building was receiving a J51 abatement during that period. Now, there is something called a J51 lookup. I think you can find it through Google. But what John was explaining earlier, I believe, was in looking at an actual tax bill. You can determine by looking at Department of Finance records whether or not a building actually received a J51 tax abatement. And I'm not sure, LaFleur or John, if you know how far back you can go in the Department of Finance now. I think maybe 2010, might be able to go a little further. But sometimes you have to actually go to the Department of Finance, find the block and lot number. You just put in the address and there's a conversion thing that'll give you the block and lot. And when you come up with the building, pick through their older tax bills to see if you find a J51 tax bill there or a tax benefit. And if you do, if there was one, then that apartment could still be subject to rent stabilization. If the owner did receive a J51 and they gave the proper notice that a J51 was being received and the approximate date when the J51 would expire, it might still come out of rent stabilization. that this is a very highly technical area. If you find that a unit was receiving a J-51 tax abatement during the period of high rent deregulation, you need to dig deeper to find out whether or not the tenant in occupancy at the time got the proper notices, and you need to ask the question whether or not the unit is still rent stabilized. So that is really the significance of J-51 for tenants. And I can't emphasize enough how many units this impacts. I've seen rent overcharge awards in the millions of dollars for groups of tenants who receive J-51 benefits where the owner did not acknowledge or recognize their rent stabilized rights and continued to overcharge them, some cases very dramatically, until a good tenant organizer or lawyer got involved and brought a case to court to ensure that they were protected. And I think there was something approaching 50,000 of these units that were affected by the Roberts litigation, where the court recognized that if you receive the J-51 benefits, you would be stabilized, notwithstanding high rent deregulation. So that's the importance of it. Got to look into J-51 coverage and determining whether or not the unit is rent stabilized. And if you have the rare instance of, a tenant who's in a 3 or 4 or 5 unit building that may also be covered by J-51, you want to check that out too, because it's a rarity in practice for lawyers to find a small building that is actually rent stabilized. But this is a situation where you might actually find that in case the owner did receive J-51 benefit. Now, I think it's a great program. I think it's, the city is a very complex place. It has a very wide portfolio of different types of housing, middle income housing, affordable housing, high rent luxury housing, and it's a very complex challenge for policymakers to manage this in a way that makes the city livable for a highly diverse group of people. And I can tell you that notwithstanding these efforts and notwithstanding these substantial investments, the city is still failing. We still have a very serious problem with affordability. Something like 9% of the housing that has been recently examined by the city's rent guidelines board is considered in distress. That is, operating costs are not covering rental income. The vast bulk of those distressed buildings are not distressed because the rents are too low or the city is, too bureaucratic and not responsive to the owner's needs, or things are too difficult. The vast majority of those buildings are under distress because the tenants can't afford to pay the rent. And the problem is really an income problem and an affordability problem. It is not a product of, some kind of ill-structured or poorly implemented public policy with respect to housing. So how do we go about dealing with that? Now, this is not really the topic for the day, but I do think it's important to introduce the idea that in order to sustain that kind of distressed housing, sustainability is a critical thing. We're looking for affordability, but we also need that housing there for decades to come. The J-51 program is a big, important, and significant part of that. And the fact that it's targeted, I think, is a wonderful reform that was overdue. But I think that the city and the state need to do more. And most of you out there know that there is a special rent increase exemptions for disabled tenants and seniors, generally referred to as SCRE and DRE. I think that when the system is reformed, which it should be simplified. It should be more carefully targeted for sustainability and affordability. What we should have is a SCRE type program or DRE type program for low income tenants in this kind of distressed housing, so that they can afford to pay the rents that the landlords need to collect in order to keep those buildings sustainable. Now, I want to say one last thing about this, and that is the Rent Guidelines Board is meeting to adopt guidelines of rent increases for the upcoming year. The arguments that are made by the industry are often targeted towards this distressed group of buildings, which actually is a little less distressed this year than it was in prior years. And the pitch is basically that in order to save housing in the city, we have to have large increases for everybody. Well, that's not true. Most owners are doing very well. The numbers bear that out. There's something like a 12% increase in net operating income in the last measure, which goes up through 2023. And I know from my own review of the statistics that owners' net operating incomes have grown very significantly in inflation adjusted terms since 1990 when we began to measure this. But there is a significant group of buildings and owners who are facing real problems and do need some help. So J-51 is one form. Another form, as I said, would be direct subsidies to the tenants by way of a SCREE or DRE program to ensure that they can actually collect the rents that are lawfully authorized. And with that, again, many thanks to John and LaFleur and Jakari and to Palante for putting this on. I think we're open to questions, Jakari, if we have anything from the audience.
Yes, but I want to thank all three of you for presenting and discussing this very much important topic. We have a few questions that came in. So the first question is, how do I find out when my abatement ends?
Sure, I think I could answer that. It's a great question. Unfortunately, there's not really a simple way of telling. Part of that is because of the way the program works. It runs out when the property uses up the available abatement. So you have this certified reasonable cost. Let's say it's $500,000. A property can only use up to 8 1/3% of that each year until it runs out. Now, if a property uses the maximum allowed, it'll run out in 12 years. If the maximum allowed actually brings their taxes down to zero, they may use less than that. So to make a long story short, you won't necessarily be able to tell exactly what year the benefits end. Old J-51 is even more complicated than that because there's both an exemption and an abatement. But if you want to know approximately, it will be between 12 years from when it was granted to 20 years from when it was granted. In terms of figuring out when it first started on the property, like Tim was saying, if you go and look at the property tax bills, you can find tax bills going back pretty far, relatively far. For the new program, if something just started, you'd be able to see what year it started. But the simple answer to your question is it's a little bit tricky. If you need details, if you're not able to find details on when the benefits were granted by what's available on Department of Finance, you can submit a FOIL request, a Freedom of Information Law request to HPD to get the actual materials from the application to see exactly when it was granted.
All right, thank
Let me
you.
just add to that.
Mhm.
If the owner is doing what they're supposed to be doing, and John or LaFleur could confirm this, I believe the tenant should be getting a notice with each lease renewal stating that there is a J-51 in place and when it is expected to expire.
Okay, thank you, Tim. And thank you, John. The next question is to Tim directly. It says, I am a STPCV lottery tenant rent stabilized. 3 years ago, my first lease said nothing about J-51 Roberts apartment. My renewal lease last year said I am a J-51 Roberts apartment. What does that mean? Am I now a part of the Roberts lawsuit?
Actually, the Roberts lawsuit concluded a long time ago, and there was one little tail end of it that came up with respect to the coverage of by the HSTPA. And the last filing on that, believe it or not, was yesterday, where the court concluded it. But in terms of the question, you may have received a rider in the Stuyvesant Town, Peter Cooper Village. There are some riders that are being submitted, basically suggesting that when rent regulation or when the lottery time period comes to an end, or if the rent regulation coverage is changed by law, then you will no longer be protected. those notices, I believe, are first of all inappropriate. Secondly, with respect to there was something about the 2035 termination period. I know that tenants are being asked to sign these riders. The riders, since they are a new term and condition, or to the extent that they're a new term and condition of a rent stabilized renewal lease, they are not enforceable. And to the extent that they are not an accurate reflection of legal requirements, they have no force and effect. So whether you sign them or not, it has no impact. At Stuyvesant Town, Peter Cooper Village, all of the tenants, with the exception of some who are in sort of dorm-like situations, all of the tenants are protected by rent stabilization. And although there may be some skirmishes down the line 10 years from now about that status and whether it's going to change, that's not something that you really should be worried about now. Keep the focus on making sure that we have elected representatives who understand the importance of rent stabilization, and continue to keep the law in place, or renew the law where necessary, to avoid deregulation.
Okay, thank you, Tim. The next question is, just to be clear, HDFCs are eligible?
They can be, yes.
Okay. It says J-51 won't increase my rent, question mark. I am rent stabilized.
Is that
I
a
think
question?
the question is like, since they're a rent stabilized tenant, if I guess the landlord gets in the J-51 program, will they rent increase? Like, that's what the question is asking.
So for the J-51R program, 50% of the units in the building must be at 80% AMI. The other 50% they're not subject to the rent stabilization requirement. So for the new program, if they are included, if they are part of the 50%, then they will remain rent regulated for the duration of benefits.
Okay, thank you. Attendee asks, can we have this presentation sent to us? HPD. Are we allowed to send out the presentation?
Sure. Yeah.
Okay. All right. Thank you. Is it legal for me to ask my landlord to apply for this? Wait, is it legal for me to ask my landlord to apply to this program? If so, how do I go about it?
It's a free country. You can ask the landlord to do almost anything, and there's no restriction on it. And to the extent that a landlord may not be familiar with it, or may benefit from it, or you may have problems in the building that might be addressed by a J-51 related improvement, then by all means. But I think that the thing to do is to, forward the information that HPD just gave today, or, give them, I think, John and LaFleur, there's a website where they can get all that information at HPD.
Yeah, there's extensive information about this program, about all of HPD's programs on our website.
Yes, just to concur, I think one of the things we noticed with the old program is that a lot of landlords are not aware that the program even exists. And so, the more information that we can spread, the better.
Okay. The next question says, I'm a rent stabilized tenant of a building who received J-51, which I believe may have ran out. The tenants and the legal services had taken the landlord to court back in 2019, which a stipulation/judgment from the court was put in place where our apartments are supposed to stay rent stabilized. However, my lease and the other tenants' leases have begun to expire this year, and the landlord gave me a lease with over a 400% rent increase. What can the tenants do in this situation?
It sounds to me like, given the facts that you've described, that this is an attempt at an illegal deregulation and an illegal overcharge. And the stipulation, entered in court is valid for decades, at least 20 years. I would you know, speak to the lawyer who worked that out, speak to legal services or legal aid, or contact one of the firms that Palante might refer you to for legal support.
Yeah, the person who wrote that, please give my office a call, 212-491-2541. And I'll put that in the chat later on. The next question is there a help desk to help buildings see if they qualify for J-51? Can you renew, and how much or at what assessment will the building be taxed after the J-51?
We do have a customer service operation in J-51. That's mostly to assist applicants who are in the process of applying or want to know about the process to apply. For a building owner who wants to explore their options, their best bet is to contact an experienced filing representative who can give them detailed advice over what they might be able to qualify for and what they need to do in order to qualify. Our business, so to speak, at HPD is reviewing pending applications. And so we're not really able to provide like a consultation for prospective applicants. But if a building owner searches online for a J-51 filing representative, they can easily find them online, and those people can provide that type of consultation.
Right.
Okay.
I think they're referred to as expediters.
Expediter, yeah.
Yeah.
Okay. The next question says there was a court order on our J-51 building stating that those who had been in the building from the start would not be forced out of rent stabilization until we moved from the apartment. The landlord has now started to send leases out and that are not stabilized leases. We've been receiving are tripling the rent and are only for a 1-year period. The person who wrote that, please give Palante a call so we can further help you with that situation. Can a Section 8 apartment also be a J-51 apartment?
Can a Section 8, was it?
It says, can a Section 8 apartment also be a J-51 apartment?
Yes.
Yeah.
Okay.
It's important to know that J-51 is a building-wide program. So it's not so much, Section 8 gives people a subsidy for a particular apartment, for a particular recipient. And J-51 really deals with the building as a whole. So you could have Section 8 and you could have several Section 8 tenants in a J-51 building.